Yes, good morning.
Morning, my lord. Forgive me, I'm just having a battle with my spectacles. My lords, I'm not proposing to revisit the points discussed yesterday. Can I add two observations? The first is that when identifying the loss of bargain for the purpose of quantifying damages on an expectation basis, the relevant task in our submission which the court has to undertake is to identify the recoverable loss. And in a commercial contract, that loss will nearly always be revenue, savings, and profit. The second observation is this: if Sisskill had not framed its claim as one for wasted expenditure, how else could it have claimed damages for its expectation loss, its loss of bargain, if you wish? The only claim that it could have made, given that it did not procure a replacement system, would have been for lost savings, revenue, and profits. Now, if Sisskill's interpretation of Clause 23 is correct, the court would be permitting Sisskill effectively to circumvent the clear exclusion of those categories of loss by claiming wasted expenditure, which is in turn only recoverable to the extent that it could have been recouped from savings and increased revenue. My lords, yesterday I mentioned another Court of Appeal decision in a case called Data Liner, and can I take you to that? It's in the Authorities Bundle 1, behind tab 8 at page 181. If your lordships have that, Lord Justice Henry gave the judgment of the court, and your lordship will see this was the plaintiffs sold vehicle body straightening equipment called jigs to vehicle repair businesses called body shops. And if you go to the second paragraph, we're concerned with a show organised by the defendants called Body Shop South, and so on. The plaintiffs incurred considerable expense in the substantial appearance of the show, but in the event got new business. A few lines down, the judge found this was because the defendants had failed to promote the show properly, and in so failing, they were in breach of their contract with the plaintiffs, and the appeal related only to quantum. At the bottom, you see from the first, the plaintiffs confined their damages to one of wasted expenditure only. They sought to recover what they'd spent participating as an exhibitor. And the judge, over the page, found that they'd incurred expenditure from which they derived no benefit at all. And the judge found, and the facts are not irrelevant because this is an application of the principle, the judge found, one, that the plaintiffs sold jigs at an average price of $15,000 each, making a gross profit of approximately 35% per jig, and so on. They expected to sell 10 jigs at this show, that expectation being based on the assumption that the defendants properly performed their contractual duties in promoting and advertising it. They went to the show with a reasonable expectation of at least doing business sufficient to cover their expenditure incurred in attending and exhibiting there. And then at 4, had the show been promoted as per the contract, they would have sold some jigs, although perhaps not as many as they were hoping to sell. And then they go on, middle of the page, the judge summarised the law, and they assessed out, and the judgment referring to the cases we've been looking at. I don't need to trouble with that. If we go over the page, we pick it up at the second paragraph. Lord Justice Henry said this: no criticism is made of that summary, nor do we find fault with it. By way of emphasis, we think it useful to quote the passage referred to from CCC Films at page 35. If, for the moment, one disregards the question of burden of proof and takes a case like C&P Haulage, where evidence or legitimate inference has put the court in a position where it knows whether, as a matter of probability, the plaintiff's recoveries on exploitation would have recouped its expenditure, then the election by the plaintiff to frame his claim on a wasted expenditure rather than a loss of profit basis does not call for any modification of these general principles. The claim based on expenditure will only succeed to the extent that on exploitation that expenditure would have been recouped. So there's a very clear statement endorsed by the Court of Appeal that a claim on wasted expenditure can only succeed to the extent that that expenditure would have been recouped. And as I mentioned yesterday, how is it going to be recouped? It's going to be recouped from savings and revenue. And then, my lords, I think if we go over the page, there's a third paragraph beginning, it is clear. It's clear from what it said, the ratio, they talk about what the judge's decision was, and then the final sentence of that paragraph, they said this: whilst this was in form a claim for reliance damages.
So you've lost me now.
I'm so sorry.
Where's this?
I'm so sorry. Page 184 in our numbering.
Yes, thank you.
And by the top hole punch, that paragraph, and I'm just quoting from the very final sentence, which begins whilst this was in form.
Thank you very much.
Whilst this was in form a claim for reliance damages, in order to satisfy the CMP haulage Middleton test, it was necessary to prove loss of profits sufficient to cover the wasted expenditure, and the plaintiffs succeeded in so doing. So that, we respectfully suggest, is a very good example of how the reliance test operates in practice. The claim for reliance losses is only recoverable to the extent that such sums would have been recouped. And it's therefore important to understand, when one looks at Siskel's claim here, how does it say it would have recouped it? And if it says, as it has to, it would have recouped it from savings and revenue, we then ask, is that excluded? And against
how is that consistent with Anglia and Reed, which is the font of this, where Lord Denning says in terms that you can have wasted expenditure where you can't prove loss of profits?
Well, my lord, we have. That's why, actually, the law's moved on quite a bit since Anglia and Reed, but effectively, the way that's been tackled by the court is to shift the burden, and that's the point about CCC quadrant and the subsequent cases, to shift the burden so that a claimant who has difficulty in proving his loss of profits it can say, well, it's for you, defendant, to prove that I wouldn't have made that profit so as to recoup my expenditure. Nothing was said by Lord Denning which undermines the principle, which is that the expenditure is going to be recouped from the expectations arising from the performance of the contract.
Well, you said that you were going to come back to me overnight about my car example.
Yes.
I know you find my car example frustrating, but principles of contract law and wasted expenditure apply to people buying cars as much as to anything else. If I contract to buy a car, and in anticipation of that, I book a train ticket to go and collect it, and I take out a loan in my bank for which they charge me, that's wasted expenditure. I'm never going to make any profit from the car. I would never have recouped that expenditure. But it would be plainly recoverable, wouldn't it, as a claim for wasted expenditure when the car's not delivered to me.
But, well, my lord, it rather depends, doesn't it? If the contract had been performed, you would have had a car for which you would have paid, taking as an example, £10,000.
Yes.
And you would have incurred that expenditure, which you would not have recovered. That is expenditure which you had decided you would incur in order to buy a car for £10,000.
Yes.
Your loss, in that example, where they don't perform the contract, isn't to reimburse you for your expenditure. Your loss is what such losses you may be able to show for not having a car for which you were going to pay £10,000. That is your true loss.
What loss could I have? I'm a private individual. I haven't got a car.
Well, if you, in order, for example, to put yourself in the position you would have been in to had the contract been performed, you incur additional expenditure to buy another car for £10,000 or £11,000, then that additional expenditure, of course, you can claim. But the expenditure you were going to incur in any event, not actually, I don't really understand on what basis your lordship is saying that is recoverable in any event, simply for a breach of...
Because Anglia Television Reed says that if there's a breach of contract and I have incurred wasted expenditure and I can't show a loss of profits, I can recover the wasted expenditure.
But we really do have to step back, I'm afraid, and understand what Anglia TV and Reed is saying. Anglia TV and Reed is not creating, and this is the whole point, this is the myth, the Burroughs myth, Anglia TV and Reed is not creating a separate head of loss for reliance loss in contract. You can't simply claim your reliance losses per se, because those are costs you would have incurred. In order to recover them, you have to say, had this bargain gone ahead, I would have recouped them in some way. Now, to come back to your car example, had the bargain gone ahead and you bought the car, you wouldn't have recouped those expenses, you'd have just had a car. And so that's why I respectfully submit the car example doesn't work.
But the theory is that I incurred those expenditures because to me, having the car was worth spending.
Certainly, but that doesn't make them recoverable as a matter of law. You still have to show the base on which they're going to be recoverable. As we all know, under sale of goods, your prima facie loss is the value of the goods that are not delivered.
Well, it seems to me that if I said I would like to recover, I've got an option of either recovering the increased cost of buying a new car, or alternatively my wasted expenditure. The law would readily allow me to do that. I don't see why it should.
Well, on what? I'm sorry, I respectfully don't agree. I mean, we can't just allow it because it seems fair, in inverted commas. One has to have some sort of structure and appropriate route through this. If the breach of contract has resulted in recoverable loss, then of course you can claim for it. But expenses that you've incurred in anticipation of a contract being performed, which you would have incurred in any event and which you would not have recovered had that contract been performed, are not per se recoverable. And Anglia TV and Reed does not say that they are. Anglia TV and Reed is very firmly fixed on the proposition, and as followed by in all the later cases, that you can recover those expenses because the expectation of the contract was that you would be able to do so. And indeed, that is why, interestingly, Anglia TV and Reed allows you to recover not only expenses that you've incurred after the contract has been entered into, but expenses that have been incurred before you ever enter into a contract. Why is that? The logic of that has to be and can only be because it's anticipated you would have recovered all of those expenses when you entered into the contract. And in that sense, it's different from a misrepresentation claim, for example, where you might, if there'd been a misrepresentation, claim your reliance loss, because there, expenses that you'd incurred prior to the contract wouldn't necessarily be recoverable. And the logic of that is because it's all about recoupment. My lords, unless we want to pursue that further, I'm proposing to move on to the clause itself. And to do that, can I go to the supplemental bundle, please? Tab 1, we're going to the agreement. Tab 1, page 40, please. Well, Lord, I'm starting at page 40. Before we get to 23.3, which is what we're concerned with, we have to see the context in which this clause is placed. So 23.2, first of all, on page 40, sets out various matters for which liability is not excluded or limited. Your lordships can see what those are. They go over the page. We then come to 23.3, which your lordships have read. I don't read it again, but I invite you just to recast your eyes over it. And as my learned friend pointed out yesterday, losses are defined in the contract on page 67. I won't go to it, but your lordships will recall they include costs and expenses. This is a provision, it's important to note, may be important to note, which applies to both parties. It's a mutual, not a one-sided clause. And then if we look at, and I'll come back to 23.3 in a moment, but I want to just set it in its proper context. If we then go to 23.4, 23.4 sets out sums which are recoverable. So it begins with a carve-out, notwithstanding clause 23.3, the customer shall, if proven and without prejudice, be entitled to recover as direct loss, and importantly for present purposes, B, the reasonable cost of running a procurement exercise and the reasonable incremental costs of producing substantially similar replacement or alternative services or systems. So, as I mentioned yesterday, the re-procurement, if Sysskill had chosen to re-procure this system, that, subject only to a financial cap...
After £122 million, I don't think it's unreasonable that they didn't. I appreciate that as a matter of contract construction, they could have done.
Well, but we have
We're
to...
not in that scenario. As a matter of fact, 23.4 is saying what you can recover without prejudice to your other rights and remedies.
Certainly. But my lord, when we're construing the contract, 122 million is an irrelevant figure.
Oh, yes. No, when we're construing the contract, this clause, you say, is part of the relevant exercise.
Yes.
It's not an exercise the judge did. There's no exercise in which we look at 23.3 in the context of the contract as a whole, 23.2, 23.4.
Well, my lords, yes, your lordship's right. There isn't that sort of analysis in her judgment. But
the first part of the appeal, because as I said yesterday, we're concerned with the construction, and I completely agree that you have to look at 23.3 in its context, and you're rightly showing us 23.4.
Yes,
because that's part of the context. I'm simply making the point that's not an exercise the judge did.
No, not in her judgment. No, your lordship's right. She was, of course, taken to 23.4.
Oh, I'm sure.
But my lords.
My lord, before Mr. Tozzi continues, your lordship should actually have been taken to the rest of clause 23.4b just to see the context in which 23.4b occurs.
Yes, certainly. Well, my lords, I wasn't seeking not to show your lordship that. In both cases on termination by customary, the agreement under 26.2a and 26.2b. And if you want to see what that's about, 26.2a is on page 47, so where the supplier is in material breach, and 26.2b is where the supplier commits persistent breaches.
Yeah.
So, my lord, that's 23.4. Then 23.5 contains the various caps, which we're obviously going to look at in due course when we come to the argument about the caps. And just over the page, at 24, over 2 pages, page 43, you'll see that IBM also agreed to provide various indemnities in respect of a number of matters, including, for example, data issues. So, my lord, we do submit, that 23.3 is part of an overall scheme providing for remedies in a complex commercial contract in which both parties had the benefit of legal representation. We refer in our skeleton, and I think it's worth just looking at a couple of paragraphs, at the decision in Transocean, particularly the judgment of Lord Justice Moore-Big. Can we just quickly look at that, please? In the authorities bundle 3, tab 21, and the passages I wanted to refer your lordships to are at page 558, first of all. Sorry, it starts actually on 557. Paragraph 14. Though it was common ground below that clause 20 is an exclusion clause, it has certain characteristics which differ from a typical exclusion clause by which a commercially stronger party seeks to exclude or limit liability for its own breaches of contract. In this case, the parties have equal bargaining power and have entered into mutual undertakings to accept the risk of consequential loss flowing from each other's breaches of contract. As I have already pointed out, the clause is to be seen as an integral part of a broader scheme for allocating losses between the parties. It is not, therefore, a simple exclusion clause of a kind at which at one time courts were willing to construe restrictively in order to avoid commercial oppression. In any event, since photo production, courts have recognised that artificial approaches to the construction of commercial contracts are to be avoided in favour of giving the words used by the parties their ordinary and natural meaning. And then he goes on to talk about Chartbrook and so on. And my lord, if we could turn forward to page 560, paragraph 21, because this is a point I'll come back to, but while we're here, can we just read this? Nor with respect can I accept that resort to the contra pro forensem principle can be justified by reference to Gilbert Ash. Lord Diplock's observation must be read and understood in context. Their lordships were concerned in that case with the question whether by agreeing to pay the contractor against certificates issued by the architect under a building contract, the contractor had agreed to forego its right of abatement or set-off under the general law. Such rights have a particular importance, and it's no doubt correct to presume that parties do not intend to give them up unless they've made that intention clear. But that is to say no more and their intention to do so must be apparent from the language they have used, fairly construed. Since the decision in favour of production, any presumption that parties to a contract do not intend to give up their right to claim damages for breach of contract must likewise give way to the language of the contract. In any event, it is clear that in agreeing to clause 20 in this case, the parties did intend to give up some of their rights. The only question for decision is whether Providence intended to give up its right to recover damages in the form of wasted or additional spread costs. And with respect, we would say that is applies to this case. I think my learned friend, I will do this, although I have to say I know I'm up against time a bit.
Sorry.
No. My learned friend invites you to read paragraph.
That's fine for me.
Paragraph 20. Can I invite you to do that without reading it verbatim?
It just contextualise.
Yeah.
So part of an overall scheme we do submit. Now, my lord, as your lordships are aware, the judge followed what we say was a three-stage process. She first of all identified, we say correctly, that an award of damage of reliance damages for wasted expenditures governed by the principle of Robinson and Harman. It is, we say, on analysis, a claim for loss of bargain, the bargain here being profits, revenue and anticipated savings, quantified by reference to the wasted expenditure. You see that in her judgment at paragraph 677 to 683. She found, as a matter of fact, that the contractual benefit lost and claimed by Sisskill comprised the savings, revenues or profits that would have been achieved had the IT solution been successfully implemented. You see that in her judgment, paragraph 682. And having identified the loss and characterised it as a loss of savings, revenues or profits, she held that the claim fell squarely within the scope of the exclusion. And that's in her judgment, paragraph 685. And we submit, in the light of her findings as to the true nature of the loss of the bargain suffered by Sisskill, this was simply the application of the words of the contract, applying the well-known principles of interpretation with which the judge was, of course, more than familiar because she'd referred to them earlier in her judgment at paragraph 266. And the fact that Sisskill formulated its claim as one for wasted costs is immaterial to that analysis, because to have held otherwise would treat reliance loss as a separate standalone head of damages when, as we've already submitted, that would be impermissible. Now, my lords, going back to the language of 23.3, there is an important point here which Sisskill haven't dealt with, but we say your lordships are going to have to grapple with, and that is this. Sisskill's interpretation of the clause would render the words excluding loss of revenue and savings including anticipated savings OTOs. And that is because lost revenue or savings necessarily fall into one of three categories. The three categories are as follows. First of all, revenue or savings which would have recouped expenditure actually incurred. Second, revenue or savings which would have recouped expenditure that would have been incurred but for the breach, but because of the breach were not in fact incurred. And the third category is revenue or savings which go beyond the recouping of the costs of the venture, in other words, profits. Now, of these three categories, the first is what Sisskill is claiming, revenue or savings which would have recouped expenditure. The second doesn't arise because the further expenditure is not incurred, so it can't be claimed as a loss. The third is excluded by the lost profits exclusion. So an exclusion of revenue and savings, including anticipated savings, only has an operative effect if it excludes the first category. Because, well, for the reasons I've explained. It's a point we make in our skeleton at paragraphs 24 to 25. It's not been addressed by Sisskill, and we do submit that part of the role of interpretation is to give meaning to the language of the words used. The parties didn't simply say loss of profits. The contract very clearly says revenue and savings, and those words in our submission, have to be given some meaning. And if you treat this as a clause which only excludes claims for loss of profit and ignore revenue and savings, then in our submission, that's not the correct interpretation of the clause. If you accept that it includes revenue and savings, then what meaning, we ask rhetorically, is being given to those words if you then limit that only to profit? So, my Lord, we do submit the language of the clause itself lends itself to the conclusion which we invite the court to draw, and which the judge in fact drew. Now, can I deal very quickly with some of the arguments advanced by Sisskill? First of all, they refer to the standard test of what the hypothetical reasonable person would have understood the contract to mean, which they refer to as the general rule of interpretation. The way they put it in their skeleton at paragraph 4, I don't need to turn it up, is we would suggest in a rather slanted way. They suggest that the judge based her conclusion on a different legal principle established in what they describe as 2 recent first instance decisions, which we assume to be a reference to Omak and Yang Sen. That, we would submit, is neither correct nor fair to the judge, because what the judge was actually doing, which we submit is the correct approach, is to identify the true nature of the loss claimed before she then decided whether the clause applied or not. So in arriving at that conclusion, she didn't rely on a principle first established in Omak and Yang Seng. She relied on principles that go back as far as Robinson and Harman, which is a decision from 1848 and indeed reaffirmed in this court on a number of occasions. Having found that the loss in this case was of revenue and anticipated savings, she then looked at the words of the contract, which could not be clearer. And if we ask the hypothetical question in what we submit in a different and more appropriate way, the judge's conclusion is plainly right. If the hypothetical reasonable person with all of the relevant background knowledge knows that Sisskill proposes to recoup the expenditure it has incurred or it's going to incur from increased revenue and anticipated savings, would that reasonable person have understood that claims for such loss or revenue were excluded? And the answer plainly is that he or she would have done, because that's what the clause says. So in our submission, the judge did not ignore standard approach to interpretation clauses. She absolutely applied it, and we would submit she applied it correctly. Lord, the second we would submit straw man that Sisskill advance is the fact that clause 23.3 does not refer expressly to wasted expenditure, and they say, oh well, but in other cases there are provisions which do so, and they cite 3 other cases. Well, my lord, we do submit, and it's a point that's in our skeleton at paragraph 26, that argument is of very limited value, or indeed double-edged to say the least. You'll have noted in our skeleton, I don't need to turn it up, but I just remind you of it, our reference to Lewison, footnote 34, that such arguments are rarely helpful, and we would submit that's the position here. In this case, nothing of relevance can be drawn from the few cases where the exclusion clause included an express reference to wasted costs. Redundancy and over-engineering are common in commercial contracts. The fact that a few draftspeople have chosen to deal with wasted costs specifically using that language is not an indication that it's necessary to do so in order to exclude what are, on proper analysis, claims for lost revenue or savings. And it certainly doesn't show any sort of customary meaning or market understanding by which revenue and savings do not include recoupment of wasted expenditure, which is what Sisskill would need to show, but has never asserted. And the same arguments apply in terms of redundancy to data, goodwill and reputation. If anything, my lords, what Sisskill's argument highlights is that they are inviting you to read the clause as if it said, after the exclusion of loss of revenue and savings, save up to the amount of any wasted expenditure. That's effectively what they're inviting you to do. They're inviting you to say, well, Where it's wasted expenditure, it's not excluded, but after that it is. Well, that's not what the clause says. Indeed, where the parties wanted to provide a carve-out, they expressly did so. We saw that in 23.4, which begins with the words notwithstanding clause 23.3. My lords, the other point we would make, just in terms of understanding this clause and the context in which the parties made this agreement, is that the agreement was made in 2015. That's 5 years after the decision in OMAC. OMAC was widely reported. It's in the Lloyd's Law Reports, Commercial England Law Reports, Business Law Reports, Construction Law Reports, Commercial Law Cases. It was the subject of numerous articles, including articles in the LQR and the Lloyd's Maritime Commercial Law Quarterly. It was referred to in all the major textbooks dealing with contract and damages. A contract between sophisticated and legally advised parties, such as the parties to this litigation, is to be construed on the basis that those parties know established principles of law, which means they must be taken to have known that a wasted costs claim in a contract such as the MSA would be based on lost revenue savings. My lords, my learned friends also refer to the decision of this court in Kudos. We would respectfully submit that that doesn't really assist them in this case, because the point about Kudos and one of the reasons, well, Justice Phillips of course knows this better than I, one of the reasons that the Court of Appeal in that case didn't accept the argument that was being advanced was that it felt that that would leave the claimant in that case with absolutely no remedy at all. Well, as we've already seen, that simply isn't the case under this contract. This contract did have an express remedy, namely reprocurement, which Siskel itself describes as the paradigm remedy for breach. You'll see that in its own skeleton. There is, as Siskel also notes in its skeleton, paragraph 37, nothing surprising about a contract which excludes some but not all types of bargain damages. And the heresy, as I mentioned yesterday in Siskel's paragraphs 37 and 38, is that it treats a claim for wasted expenditure, reliance loss, as if it's a standalone claim for loss of bargain damages caused by the breach. Contrast reprocurement costs, which are caused by the breach. They, of course, would not otherwise have been incurred. Contrast that with costs which would have been incurred in any event. Now, my lords, and so, yes, the terminology that's used in some of Siskel's skeleton, it says it's a kind of loss of bargain damages. You'll see this in paragraph 38 of the skeleton. Similar in material ways. It's none of those things. It is a claim which is wholly dependent on recoupment. And proof of expenditure is just an evidential means that can help a claimant prove lost revenue or savings. My Lord, Gilbert Ash is also referred to, the need for clear words and so on. I make 2 points in relation to that. First of all, I do submit that the words are clear, and I already referred your lordships to what Justice Morbick had to say in Transocean, which we say applies here. Secondly, there's nothing unfair about clause 23.3. It would be unfair if the contract excluded all remedies, but because it expressly provides for certain types of claim, including what would have been the substantial claim for the paradigm remedy, namely reprocurement costs, and also for other costs as a consequence of breach, for which a substantial claim was made and upheld and stands unchallenged in this claim. There's nothing unfair in a contract which excludes certain types of loss. And so we don't get close to Gilbert Ash in our submission. Motortrack, the decision of Mrs. Justice Mulder, Siskel suggests that what is, they recognise, an obiter remark by an experienced commercial court judge suggests that a reasonable observer would not have concluded that an exclusion clause would encompass claims for wasted costs. Well, with respect, no such conclusion can be drawn. The obiter observation in Motortrack was made without any analysis, without any consideration of the authorities which were identified by the judge in this case. And that is for the very good reason that there simply wasn't a wasted costs claim in Motortrack. None was being pursued. The judge wasn't taken to any of those wasted costs cases, and I can say that with some certainty because I was in the case. It is, with the greatest respect to Mrs. Justice Mulder, no more than a throwaway comment, and one can't draw any great conclusions from it. Finally, my lords, on issue 1, I said I was going to ask Mr. Kramer to deal with the article by Professor Peel, and I think there's another case he may want to take you to. And so, with your lordship's agreement, I'm going to sit down and let Mr. Kramer take it. Thank you.
I should say that some years ago, Youthful Counsel said that, in front of me, said that he now wanted to take me to the bundle of authorities that dealt with the academic articles, and rather more experienced counsel stood up and said, I can tell that my learned friend has never appeared in your lordship's court before, which is slightly harsh, but doubtless that's a reputation I deserved at the time.
Yeah.
But yes, by all means, Mr. Kramer, let's hear you on Professor Peel.
Well, those who know me know that I won't be confining myself to Professor Peel, and I may use Professor Peel as an opening to make a few other points which may interest you even if they're not professorial. Professor Peel's article is instructive, we say, and I'll come to it in a short while, because it mainly helps IBM, not CIS. And this is because there are three, as I see it, three main structural points that are arising on this exclusion clause issue. And Professor Peel, the editor of Tritle, agrees with us on the first two of them. And I also say that's not surprising, because to disagree with us on either of the first two of them is to disagree with the law in OMAC, Yam-Seng, Gold Trade, which I'll come to, the commentators. The third point is the one we really should be arguing about, which is construing the clause, given that the claim is for savings and revenue, and I'll come to that. But the first two, so the first point is, there is no wasted expenditure claim here, because there is no such thing as a wasted expenditure claim. A wasted expenditure claim is always a claim for something else. That means that CIS's claim is not a claim for wasted expenditure. When Mr. Thankey said at page 8 yesterday, the claim is for actual incurred costs, not unrealised benefits, he was dead wrong about that on the law. Our skeleton, paragraph 19, touches on this. That's core bundle, page 49. And you'll have seen that.
Sorry, which paragraph?
Paragraph 19. So, my lords,
Yeah.
and I will say that Professor Peel agrees with us on that. We'll come to that in a moment. Issue 2, if one accepts that proposition, then we're on issue 2, which is what is the claim actually for? And that varies. But in this case, issue 2, the claim is for savings and revenue and nothing else. Now, different types of loss, this is almost too trite to say, different types of loss may be claimed and claimable and recoverable in different types of cases, subject to remoteness, subject in non-pecuniary loss cases to the main object of the contract principle from holiday cases and Farley and Skinner and Brooks Electronics and these sorts of things. So a claim in another case may be for non-pecuniary loss. In a holiday case it would be. In an NHS case it would be probably. But not in this case. I'll come back to that later, but this is not a claim for non-pecuniary loss. The judge so found. What that means is non-pecuniary loss is not recoverable here. It wouldn't be if pleaded expressly. And it's much too late for the claimant to try to suggest that it is. Now, I'm going to briefly return to the lit firework of the car. The car is not straightforward because non-pecuniary loss is not straightforward. And it never arises because the Sale of Goods Act has a very complex structure of remedies. And if that doesn't happen, that doesn't satisfy, then normally you will either get your money back under total failure of consideration, return of the price, or you'll buy a replacement. But in the scenario posited where none of that happens and you've spent expenditure looking into cars and then you've bought a car, what your claim is for non-pecuniary loss, like with a holiday, like with a swimming pool. How much can you get? That's quite tough. It's always tough to quantify non-pecuniary loss. One way you can do it is you can say, I presume that my expenditure would have been recouped by my non-pecuniary benefits. That's what Mr. Justice Tier says in OMAC at 56. So in a non-pecuniary loss case, you can use the wasted expenditure as a helpful proxy there too. And in fact, it's more helpful there because it's even harder to quantify the loss. Quite how that works is a matter for the particular case. If I have an idiosyncratic interest in 1984 Ford Anglias and I pay a private detective £1 million to track one down and then I claim that, whether I can recover £1 million plus the cost of the car will depend upon whether that loss is too remote, and it being idiosyncratic, it probably is. If I've got more modest costs and I've paid for the car, I may be able to recover not just the value of the car, I may be able to show that my valuation of the car in non-pecuniary terms is greater than the price, but includes these extra expenses. Or I may not. It's an economic question. Do people just hazard costs in their life that they don't really expect to recover? Or do I have some sort of consumer surplus whereby I actually value it more than the price? And you can have that argument, but we are not in that case. We're in a much, much, much more straightforward case of financial loss. So the car is fine for us, and a difficult case. Unfortunately, we don't have to answer the car case, but it's not problematic from a principal point of view. Why? Because in the car case, non-pecuniary loss is recoverable, and the question is quantification. In our case, savings and revenues are recoverable, and it is a question of quantification. So the second issue, the answer we say is, in this case, this claim under this contract is for revenue and savings only. And we say Professor Peel agrees with that too. That then leaves the third issue. Given that it's a claim for savings and revenue, is it excluded by a clause that expressly excludes savings and revenue? And that is the issue Professor Peel engages with. Can you read down the word savings and revenue?
Forgive me,
Yes.
I'm just struggling with the constant repetition of the claim. It's only for revenue and savings. What if the exercise of obtaining an alternative system would have cost 3 times as much?
The cost of cure would have been disproportionate to the benefit. In that case,
Well, they what if obtaining an alternative system would have cost 3 times as much?
what if it would?
Well, that would be you'd have a claim for loss of bargain damages, but that wouldn't be a claim for revenue or savings.
So I can claim the cost of reprocurement if I incur it or if I intend to incur it. Standard for all construction projects, of course. And if it's disproportionate to the benefit I would otherwise get, then I may be disallowed it as it being an unreasonably disproportionate cost of cure, in which case it's irrecoverable. If it's proportionate and I am going to incur it or I have incurred it, I can recover it as a consequential cost. And then I have to look at my exclusion clause and say, does it exclude consequential costs of reprocurement? And in our case, it doesn't. There's just a cap.
I don't understand that it's not consequential loss, is it? The core. If I buy a cargo of a consignment of goods, and I do not get it, my loss is the cost of going into the market and buying another equivalent cargo. That's not consequential loss. That is the core loss that anyone entering a contract suffers. That is the loss of bargain, the cost of obtaining a replacement.
Forgive me, I didn't mean consequential in the Hadlin-Baxdale type term. It's a consequence. You incur it as a consequence rather than it being a wasted expenditure. You're quite right, of course, my lord. The typical the typical remedy in most cases, especially of fungible goods or fixable property, is the cost of cure. And that is a claimable loss. Within the loss of bargain, the loss of bargain is not an especially useful term. It just means the expectation loss. And why can you recover it? Well, because by curing, you're using money to put you in the position you would have been in. It's the best way, in some ways, of avoiding the complications of quantifying the losses that happen otherwise.
This isn't really a question of cure, is it? This is a question of how do you assess what you have lost? And the classic way is to say, what is the market value? And you say, well, I was to get X. How much? What was the market value of those goods, of that service, or whatever? And your loss is the difference between what you were contracted to pay and what it would cost to replace it in the market. And I think getting hooked on concepts such as cure obscures the basic contractual test of contractual losses, which is how much in the marketplace would it cost you to get a replacement.
You're deemed to get a replacement by the principle of mitigation and legal causation, and therefore you're quite right, of course. That is the standard measure, and it's in the Sale of Goods Act. If I may run at this by a different route, can I go through the Gall Trade case and then address with you why reprocurement is not relevant to the wasted expenditure recoupment? So I'm going to park it, but I will come back to it, and if not, then I'll doubtless face the consequences. So the case I'd like to look at before Professor Peel is the case of Gall Trade, and I don't have much time, so I'm only going to look at one part of it. But Gall Trade is a case of Authorities 10. Page 205.
Just for my note, are we looking at this before you go on to Professor Peel on your third point?
Well, on all 3 points.
Right.
The third point will be most relevant when we get to Professor Peel, and is the point of how you construe the words.
Okay, so which tab did you say?
Tab 10,
Yep.
page 205, A205 it's called. Paragraph 1, very briefly. The claimant was a buyer of fuel oil. There was a non-compliant parcel of the oil. The claimant rejected it and claimed damages. The rejection was in fact wrongful, so the claimant was only in fact entitled to damages for breach of warranty, and was effectively deemed to have retained the oil because it shouldn't have rejected them. That complication doesn't need to concern us. What I'm going to jump to is paragraph 106, which is at page 248. Sorry, I should have said, you'll have seen this as a decision of Mr. Beltrami, QC, sitting as a deputy. Paragraph 106 confirms that the only pleaded claim is for wasted expenditure. And just while we're here at paragraph 108, there's no market. This is a claimant claim, a buyer claim. There's no market for replacement of these goods in the immediate, so at the time they were needed. So it's got some similarities with our case and indeed the car. The section I want to look at is at paragraph 123, which is at page 255 onwards. Because what this addresses is the mechanics of the presumption and its rebuttal, which we say Mr. Thankey has tried to keep you away from, because what that shows is what's really going on, what a proxy means. So 1, 2, 3, there's an explanation. Well, firstly, there's a mention that there's expert evidence. We'll come back to that. And a mention that this question is obiter because of the point about rejection. At 1, 2, 4, there's a reference to OMAC. And then the explanation in the last sentence, the premise is that it would, in that event, have generated profit, or at least revenue, which would at a minimum have recouped the level of expenses, so they were not wasted. And then at 1, 2, 5, first sentence, this means such a claim has validity only if, and to the extent, that the court is satisfied the claimant would indeed have generated the necessary revenue to recoup the expenses.
Isn't that just OMAC? Isn't this
It's just OMAC, yes, this is the law. But what I'm...
Are we looking at this for principle, or what are we looking
I'm going
at
to
this for?
show you that this is a claim for revenue. In our case and this case, and that's all it is. Once you accept that, then you address the clause which excludes revenue, and you say, why is it not excluded?
Right, so 125.
And then 125 first sentence generated the necessary revenue. That paragraph was quoted with approval. There's been a case about a week ago of Mr. Justice Butcher that neither of us have put in because it doesn't really add to the law, but just in case you want the full picture of consideration of this issue, it's the cardio-rentis case. We could supply. 126, there's then the first sentence which talks about the presumption that you would generate enough revenue to break even. And then the last sentence, which addresses a point I think my Lord Zacaroli mentioned, which was the principle also operates as a cap. There's a sliding scale under which a claim may be able to recover more or less of its expenditure depending on how far it would have missed the break-even point. In other words, it's not a binary situation. You recover exactly as much revenue as you would have earned.
Well, you just skipped over the quotation from your book.
Yes. No, the burden is very well here. The burden's not a problem for me on this point because I'm dealing with the exclusion clause. The burden will be a problem for Mr. Tozzi later, where we deal with causation, and we don't disagree. The burden falls heavily on the defendant in these cases. And then 127 talks about what happens when you're rebutting the presumption. What does a court do when the defendant says, I don't accept you would have recouped your expenditure, which we pleaded in this case? The court must consider on the burden of proof the question of the claimant's profitability. And then there's an explanation that this is in order to resolve uncertainties about what would have happened. This is why you have the presumption. It's the defendant who's put the claimant in the difficult position of proving what it would have earned. And so the defendant gets a fair wind, a bit like chimney sweep. Army and Delamere. And then 128, just without reading them, but we can see there's some detailed consideration of profitability, as the judge said was going to be considered. Now, there's no question about the value of the oil as property. It obviously had a market value, although it couldn't be replaced here, so that's why it was a revenue claim. And there's no question of some general measure of benefit in the contract. This was an oil trader, and the question was what revenue or profitability they would have earned. And then paragraph 135 mentions that there were experts about profitability. So in gold trade, when the claimant advanced its claim for wasted expenditure, it knew it was claiming lost revenue. It called expert evidence as to lost revenue, and there was an argument about revenue and profitability. And where did that go? Just jumping forward, it went to paragraph 137. The judge says that the presumption was unrebutted, so the burden had not been discharged. Now we'll come back to the exclusion clause. There was an exclusion clause in that case. But that shows you that this is a revenue claim, and as soon as the presumption, which is only an evidential assistance to the claimant, it doesn't change what you're trying to presume. It's a presumption as to recoupment, as to revenue. Once that arises, you get into proving revenue one way or the other. But the claimant has assistance. So in a case where you've got no way of knowing, the defendant's going to be unable to rebut the presumption, like Anglia TV and Reed. How much would the TV programme have made? Very hard to say. Presumption remains unrebutted. Where you've got a business...
The defendant can't rebut the presumption.
The defendant can't rebut the presumption. Yes. Now, just to pause there, there's the question of reprocurement costs. Could the presumption, and this is a question my lords raised, could the presumption or the recoupment be some loss of bargain more generally? Could it be about reprocurement costs or replacement costs on the market, which is, of course, a core or paradigm remedy, as we're all agreeing? The answer is no, it cannot, for a number of reasons. It's not because reprocurement's not loss of bargain, those words don't really help us here. It's because that's not what the presumption is about. Now, the uncertainty that's identified by my Lord Legate in Yam Seng is the uncertainty about what would have happened. The defendant has put the claimant in a difficult position of not knowing what would have happened. And in assisting in that, there's a presumption. But reprocurement costs are nothing to do with that. Reprocurement costs are not the what would have happened counterfactual. They're an actual cost that is incurred or not incurred. You don't need help proving reprocurement costs. Secondly, the reprocurement costs or the cost of cure, they don't defray, they don't recoup anything. That's not what they're doing. Revenue recoups expenditure and then takes you into profit. And that's what all the cases are talking about. Reprocurement costs do something else. They give you a form of specific performance, but by a different party, by a third party. Anyway, the presumption, if it made sense, would be very easy to rebut. Presumption, reprocurement in some way has recouped the wasted expenditure. Rebuttal, no, you did not reprocure. There was no cost of reprocurement that you can recover because you didn't incur it. As a matter of fact, not disputed here. So Mr. Thankey's never said, the claimant's never said that the wasted expenditure presumption could be rebutted by showing it's not incurred the cost of reprocurement. It's never claimed the cost of reprocurement. That is not the claim here. So that can't be the benefit the wasted expenditure is a proxy for. And there is no case, there is no authority ever suggesting, because it's, for the reasons I've given, nonsensical, ever suggesting that the wasted expenditure presumption is rebutted or relates to reprocurement costs or cost of cure. It's just not what it's about. It's about quantifiable benefits that you would receive, which will be either financial or non-financial. That is also true of the idea that there's a general, the system itself, or some general benefit of the contract, of the service, is the value that's recouping the presumption. That can't be right, because that measure is not available in this sort of case. You can't, like in Galtrip, you can't just claim, let's forget what I would have done with the system, I just value the system itself. The idea that you could claim the value it would have for your company, that doesn't work either. I think Mr. Thankey made a suggestion yesterday that, well, it might have increased the value of CIS on its sale to market study. That's maybe right, but that's not a claim CIS could ever make. This is not a share purchase agreement. CIS is itself a company that earns revenues, and it can only claim the lost revenues. And that claim has never been advanced and would never be advanced, and it's not pleaded that there's a claim for the value to the company. You have to identify the claim in this case. In another case, particularly where let's say you buy a drill ship or a swimming pool or something, then of course you may be able to value your loss by the value of the thing, because that is essentially something you're going to retain or maybe trade. But that's not the case with an IT contract, and it's never been suggested at all in the skeleton or before that what needs to happen is to look at, well, the value of the thing itself. My lord wants to say something. No. No? Well, that's a rare pleasure.
May I say something instead?
Yes, of course.
You focus wholly on the concept of recoupment of the wasted expenditure. And that's what leads you down the road of revenues, because that's the only thing you can actually recoup, is if you get some money in, i.e. revenues. But the test is broader than that, isn't it, as expressed in OMAC. The presumption, and what the defendant must be able to show, is that the expenses exceeded the benefit expected to be obtained from the contract, which
Yes.
is not just recoupable revenues, but the benefit which it could include, which I think is referring to loss of bargain, isn't it?
It's referring to any recoverable loss.
Which could include my Lord Justice Phillips's analysis of loss, which is the cost of replacement.
In the right case, the cost of replacement, yes. No, not here. It's any recoverable loss that you can claim that is therefore recouping. The loss of bargain analysis, this point wasn't before Mr. Justice Tier. He was considering a case about buying and selling of something, and there was no question of this reprocurement idea.
Well, he was considering a case where they were better off because of the repudiation, which is a million miles from this case. All of these cases are considering that we've had, are considering cases where, situations where, effectively somebody is seeking to argue, not expressly but impliedly, that it would have been better for them if the contract had never happened, rather than the right test, which is, was the contract performed? And a lot of them are also concerned with whether or not it's a bad bargain. You can't show that you, in fact, would have recovered these costs you spent, because this contract was always going to be a bad bargain for you and you'd never have recovered this money. Those are the prime factual scenarios which are being dealt with in these various authorities. All of that's a million miles from this case, where, to take the biggest head of loss, the £30 million was paid for a IT system that was never delivered, so that CIS could have just simply sat in a corner and burnt the money.
My lord, no one is suggesting that they can't claim the lost revenue and savings that would have recouped.
I understand that, but that wasn't the purpose of my intervention.
Well, my lord's angry with what might have happened to Claimant. I'm telling you why the law is not causing a problem.
No. It's a question of all of these cases are dealing with, as cases do, specific problems. OMAC is dealing with a very specific issue as to effectively whether the claimant were entitled to ignore the fact that they were in a better position because of the breach. And they weren't. Perfectly understandably.
Perfectly understandably.
But I think that goes back to my Lord's point about the focus on recoupment.
Well, none of the cases are about recoupment. And the reason for that is it's nothing to do with wasted expenditure. Recoupment is recoverable if it's recoverable. And if it's not, you don't need help proving it. The wasted expenditure is a rule of evidence that helps you prove benefits in the counterfactual world. What would I have received? And that is the only way it makes sense and works. And that's all I'm saying about those cases.
Let's have one more go at this.
Yes. Mr. Tozzi's going to probably pull me to the floor. Yeah.
We'll look forward to that. The recruitment costs, it seems to me, are just another way of the obverse of profit. They effectively amount to the same thing.
There's a lot to potentially unpack there, but all I think I would say to that is, if there was a claim for recoupment costs, then we look at the exclusion clause and say, is the exclusion clause as worded an exclusion of recoupment costs?
No, leave aside the exclusion clause for the moment.
Yes.
What you're saying to us, as I understand it, is that that the wasted expenditure is a proxy for profit, revenue, or savings.
In this case.
Well, I think.
Or non-pecuniary benefit.
I think we're only looking in generalities now, aren't we? Because in this case, if we are looking at this case, you have to then look at construe the clause as a whole. But as I understand it, what you're saying to me is when you look at this clause, you have to understand what the law is to understand what was intended. Isn't that what you're addressing?
Well, yes, but it's not a question of only professors can get the right answer with this clause. It's a question that what I was trying to show you through Gall Trade is that everybody would understand who understands the law, and who, this includes litigants, in Gall Trade. Let's put it in these terms. In this case, the claimant was faced with the desire to claim damages. It knows that the loss it suffered is savings and revenue and potentially profits. It does not formulate a claim for that expressly because it knows the clause is a problem for it. It also tries to get around the clause. It pleads willful default. That fails. It pleads different breaches of contract whereby these costs were not merely wasted, they were a cause of the breach, because the breach was not much earlier, but that failed. So we're left with, how is the claimant to pursue the claim? In Gall Trade, the clause was not such a problem. The clause only excluded loss of profit. So in Gall Trade, it was happy to come forward and say, yes, this is a revenue claim. It doesn't matter about profits because I'm only trying to go up to the recoupment level.
I'm not sure I really understand the sort of approach this on the basis of motivation of the claimants or how the claimant claim losses. There is no doubt on the basis that we are assessing it, that the claimants did incur this expenditure. Now, whether they have chosen to claim that expenditure because they perceive legal advantages in this case or not seems to me irrelevant for our purposes at the moment. The question is that they incurred that expenditure. As I said, what you're saying to us is, well, that expenditure must be analysed as a claim for revenue or profits, revenue or savings. That's the legal analysis of it, is what you're saying, as I understand.
What I'm saying is what they pleaded by their plea for wasted expenditure, what they realised, knew, understood, were advised, that plea meant was this. We claim for revenue and savings, but not profits. 2, for quantification, we rely on the presumption that revenue and savings would have equalled the amount of the wasted expenditure. They know that in law is what they are claiming. But can they, by just pleading the second of those, just pleading the evidential rule, bypass the exclusion clause, change the nature of the claim? No. They're doing quite well so far through Mr. Thankey's silky submissions, if I may say. But that's what that would be doing. It would be ignoring the legally implicit, well understood, number 1, we claim for revenue and savings but not profits. And that is what Ms. Justice O'Farrell found were the benefits that would have been recovered. She had heard evidence where there was a 2014 strategy report that set out the profits overall from gross premiums. She knew all about the system and how it would be implemented. That is what the claim was for. But the claimants, they're not silly, so they don't plead the words, we claim revenue and savings, in this case, because of the exclusion clause. But that is what they claim, and they know that's what they're claiming. They just plead the evidential rule. And then we plead back, you would not have recouped those revenue and savings. But that's it. That's where the pleadings sit. And then we just have the evidence, and we have the arguments, and we have construction. You have to imagine, I'm saying, that they had put those words in the claim. C claims revenue and savings, but not profits. That's what they claimed. That's the only legal sense in which their claim makes sense. And that's what was pursued. Now,
it's a novel approach to say that we're going to decide this case on something they haven't pleaded.
Well, my lord will understand what I'm saying. Pleading an evidential rule is strange. It's a strange way of going about it, but it's because of the history of wasted expenditure. It used to be thought to be a separate measure. And pleading probably needs to catch up, and pleadings probably do need to say what I just said. So the defendant can then say, you can't, this is a non-pecuniary case, or your revenue's too remote, or whatever. Well, that didn't happen.
Well, even if it is a frame, as you say, it's a well-recognised formulation, and a party seems to me cannot remotely be criticised or be read down by claiming wasted expenditure. And it's such a well-recognised formula that parties very often will include in their exclusion clauses, as in kudos, exclusion of wasted expenditure.
That has happened.
The people who drafted that clause as well also must be taken on your analysis to know that that was completely odious.
That has happened 3 times in the history of the world.
Sorry, say again?
3 times in the history of the world on the reported cases.
Well, that's on the reported cases.
There are many more cases.
Yeah.
This is a word search world. It's not hard to find them. That's how they are found.
Yeah.
So I wouldn't take much from
the
that.
vast majority of cases don't end up, vast majority of contracts don't end up being reported in the law reports.
There are many reported contracts, even where the dispute is not about the exclusion clause, but I accept that.
Are we going to get on to Professor Peel?
Well, let's get on to Professor Peel.
Just
before I do, I'm
going
to tell you, without going to it, that paragraphs 138 and 139, I would ask you to read them, of Gall Trade. Mr. Beltrami deals with the exclusion clause there of profits. It's got profits, it doesn't have revenue and savings. and he therefore doesn't have the issue we have, and he unsurprisingly says, well, wasted expenditure is only about revenue up to break even, so it's not excluded by a profits term. And we say that our case is supported by that, because obviously we have the extra words. Now, Professor Peel's article, very briefly, is at the final volume of the authorities at tab 26, page 716. Now, what he does is none of the things that Mr. Thankey suggests that you do. And he's the editor of Triple. He knows the orthodox law, if I may say. He doesn't suggest that there's some other benefit involved or reprocurement costs. He doesn't say wasted expenditure is a different type of loss. So, of course, those words don't cover. What he says, and I only need to take you to about 2 sentences. One of them is on savings. It's at page 428. And it's at near the foot of page 719 in the bundle. The middle paragraph, the last sentence, CIS had spent. He says CIS had spent 128 million. Only when the benefit obtained in return began to exceed that would it be correct to say it was making a profit or any savings. So when it sought to recoup the 128, it was not making a claim for profits or savings. So he makes an argument, and this is the right sort of argument, although we disagree with it, that the meaning of the word savings should not be read to include savings up to break even. It should only include savings beyond that, which we say is the right argument to make, but is wrong because it's strange. Partly for the reason that Mr. Tozzi gave, that it then has no meaning at all, because you're already recovering profits, excluding profits by the term profits. And then on revenue, at the top of page 429, we look at the last sentence at the top of bundle page 720. We see, he says, as far as this clause is concerned, the question is what the parties mean when they refer to loss of profits or savings. There are several reasons to support the view they mean net profit or savings, by which he means what he's just said, which is only savings beyond break even. And then there's the footnote 20. Clause 23.3 also refers to loss of revenue. The concept of net revenue is not free from difficulty. But he submits, nonetheless, it should be interpreted to refer only to sums that would have been generated once expenditure had been recouped. He realises that revenue on its face is much beyond profit because it's all revenue that's taken in. But he says he wants to read it down to only be revenue beyond break even, which is the right approach to try to overturn the judge. You have to read the words. But what sits behind this is he has rightly accepted my issues 1 and 2. He's accepted this is a claim for revenue and savings, but he's saying, I want to read down the words revenue and savings. And that's an argument that we're prepared to have, of course, and we say, well, that's very difficult because the words are clear, which is why Mrs. Justice O'Farrell didn't have much difficulty with that point. Just for completeness, in the last paragraph of Mr. Peel's article, he actually goes even further. In the middle of that paragraph, which I think Mr. Thankey took you briefly to, he talks about wasted expenditure. He says, the prudent drafter will, of course, make express reference to wasted expenditure. But even there's a question. Do you see that? The second sentence of
5 lines down, 4 lines
final
down.
paragraph. And then he suggests that it may be the better interpretation is that even if there was an express exclusion of wasted expenditure, it would only be expenditure going beyond the price paid, which is something even Mr. Thankey doesn't suggest. He doesn't say that if the clause included the words wasted expenditure, only some of his expenditure would be excluded. So Mr. Peel is, in this respect, something of a extremist in that he feels strongly that recovery going up to break even is something it should be very hard to exclude. We disagree because this is a commercial contract with a complex clause, etc. But I wanted to situate where we should be within Professor Peel's article. He starts with the clause, he accepts there's a claim for revenue and savings, and he then tries to read down the words, which we say is the right exercise, but the wrong answer. My lords, I'm going to sit down unless you have any more questions.
So the reasonable observer would be falling into error if they were guided in what this contract meant by Professor Peel.
Well, they hadn't read his article at the time, but
no, of course not.
They rightly would understand the claim is for revenue and savings. They would look at the clause, and then we're in the right territory. We say Professor Peel is wrong.
Exactly.
He's not taking the reasonable observer's point of view because he's overly opposed to the exclusion of costs up to break even. We say, well, and this is not a point he addresses, there's no meaning for the words revenue and savings in that context, as Mr. Tozzi said. And also there's an express recoupment remedy that's permitted, so we're not in kudos territory.
As I say, what you're saying is that he agrees with your analysis, but his qualification is as to the construction of the clause.
I'm sorry, I didn't hear the last bit. His qualification
is as to the construction of the clause.
Yes.
He reads the exclusion as only relating to net.
Yes, his form of net. I trespassed on Mr. Tozzi's time. I'm not sure he'll forgive me, but I hope he will.
My lords, could I move on to issue 2? That is the question of dispute, as identified by Melanie Fremster. Thank you. And as your lordship will appreciate, the judge found that the application gate 5 invoice was disputed, and in those circumstances, IBM didn't have the right to terminate. If the judge was wrong on that question, then it means that the termination was lawful termination, subject to the set-off point, which is issue 3. My lord, on the dispute question, there are 3 reasons why we say the judge erred on this point. Each operates independently of the other, so I only need to succeed on one of them for the judge's conclusion on this point to be overturned. The 3 points are, firstly, that the email relied on by Sisskill did not dispute the invoice as required by paragraphs 11.5, 11.11 and 11.12 Schedule 5 to the MSA. The second is that if the invoice was disputed, that was not done in good faith, as that term is properly to be understood. And the third is that the dispute relied on by Sisskill requires it impermissibly to rely on its own breach. And I'm going to take each of those points separately, if I may. So the first point, which is that the email relied on did not dispute the invoice. Your lordships were taken to the email yesterday. It's an email of Rachel Clough. If your lordships wish to look at it again, I wasn't proposing to take you back to it. It's supplemental bundle, tab 9, page 135. In order to consider whether this email disputed the invoice, it's necessary to say something about the context in which this email was sent and the way in which the agreement, the MSA, was intended to operate. And I make a number of points. First, as your lordships will be aware, AG5, Application Gate 5, was the 5th and final stage payment for off-the-shelf software licenses which did not relate to project progress. You'll see that in the judgment, paragraph 273. Second, IBM made a clear request for a purchase order in respect of the AG5 milestone at a commercial management group meeting on the 14th of December 2016. That's in the judgment, paragraph 277. Third, the application gate 5 milestone became due and payable at the beginning of January 2017. It's the judgment, paragraph 277. Fourth, Sisskill was obliged to approve the AG5 milestone and to issue a purchase order number for it, and its failure to do so was a breach of the agreement. Judgment, paragraphs 277 and 279. Fifth, the judgment at paragraphs 255 to 262 refers to various internal discussions within Sisskill. None of the observations contained in those discussions or those emails were shared with IBM. IBM was not told by Sisskill that it had made a conscious decision not to issue a purchase order number in breach of the MSA and not to pay application gate 5. Sixth, if I can just take you back to the contract, clause 14, it's in supplemental bundle tab 1 at page 29. Clause 14. Clause 14 says this: in consideration of the performance of the services, the customer shall pay the supplier the charges as set out in and or as calculated in accordance with Schedule 5 charges, which shall be invoiced at the times and in the manner specified in Schedule 5. So that was the contractual requirement dealing with this. And seventh, if we then go to Schedule 5, which is in the same bundle behind tab 4, which deals with charges, and if we look at paragraph 11.5, which is on page 94, that says, unless otherwise set out in a statement of work, the supplier shall invoice the customer in respect of the charges to which it is entitled under the agreement within 180 days of the date on which the supplier completes the relevant milestone, and so on. Any charges which are not invoiced within this time frame shall not be recoverable by the supplier. This was not something that IBM could just leave in abeyance. IBM had to invoice for application gate 5 within 180 days at the latest. And the provisions which say it doesn't apply where there is a dispute simply don't arise because, as I mentioned earlier, my point 5, IBM was never told that this item was in dispute. My eighth point is this: the MSA contained a detailed dispute resolution process which is set out in Schedule 19, the MSA. If you just turn to tab 6 of the same bundle, supplemental bundle, page 101, you'll see, we don't need to look at the detail of it, but you'll see there is a whole schedule with dispute resolution which runs over 3 pages, setting out how matters were to be approached in the event of a dispute between the parties. That is a process. If we turn back to Schedule 5 behind tab 4, paragraph 11.12, which is at page 95, that was a process that was referred to in 11.12, provided the customer is given the notice in 11.11, the customer may withhold payment, meet with the supplier to discuss the disputed amount, and so on. And then towards the end, it says this: if after they've had a meeting, the disputed amount has not been agreed, then the customer and the supplier shall resolve the matter in accordance with the dispute resolution process set out in Schedule 19 of this agreement. So there's a process which involves requests for provision of information and followed by a more formal dispute resolution procedure. And for that contractual regime to work, IBM need to appreciate that its invoice has been disputed. If it doesn't know it's been disputed, then it doesn't know that it's got to start that process. And that means that any notification of a dispute has to have sufficient formality and clarity that the parties would know that the process was engaged. Ninth, the invoice was submitted by IBM to Sisskill on the 24th of March 2017. It was sent by IBM to the email address identified by Sisskill as the one to use. You'll see that in the judgment, paragraphs 245 to 249 and 311. There is, as your lordships would have seen, a half-hearted attempt by Sisskill to resurrect, we would submit really as a jury point, the argument that the invoice was not submitted properly because it was not copied to members of Sisskill's project team. You see echoes of that in Sisskill's supplemental skeleton argument, for example, at paragraph 5.9. That is an argument that was firmly rejected by the judge and against which there is no appeal.
Could I just clarify? It was sent on the 24th of March.
Yes.
Was that where was that within the 180-day period?
So my lord, the sum fell due at the beginning of January. So it's about 3 months.
Halfway
So it's
through.
well within.
Yeah. Oh, it's well within the 180 days.
Halfway
yes.
through, 180
So,
yeah.
is about 6
I've done
months.
the
So,
arithmetic, but yes.
yeah.
So when the email came back saying, well, there's no purchase order on that, your clients either understood that there was no real dispute, in which case they would get a purchase order and resubmit it, or they understood that there was a dispute because a purchase order wasn't being provided. Which was it?
Well, my lord, that's to ask the wrong question with respect. I'm going to come on to that because that's an error that the judge made. It's not how we internally may have interpreted it. In fact, what happened is that it was simply put into a box within IBM, and I'll show you some evidence about this in a moment. Invoices are either accepted and paid, or they're put into a category called disputed, but that doesn't mean but that does not mean they're disputed. And that's exactly the mistake the judge made. It's to treat IBM's internal processes as somehow determinative of whether objectively, which is the right test, objectively, that email disputed the invoice within the meaning of the relevant paragraphs of the MSA, which I'm going to take your lordships to.
But the manner in which your clients dealt with it is not irrelevant to assessing an objective, how the objective reader would react, is it?
Well, my lord, it is actually. It's inadmissible evidence, isn't it? Because the notice has to be assessed at the point at which it's given. So one looks at the notice.
So that you can say we had no idea that it was disputed, even though, as a matter of fact, it was.
Well,
because it's an objective test, and you knew it was disputed, but that was subjective, or it was after the event, or whatever.
well, but my lord.
I mean, it's traditional that courts do tend to look at that material.
Well, but my lord, one could equally say we looked at our contract and we all we could see was a request for us to resubmit with a purchase order number.
So was there on the the email was the 27th?
27th, yes.
Yeah, so on the 28th, was there an email saying, please can we have a purchase order number?
My lord, I can't off the top of my head remember.
I mean, there's no reference to that. That if this was all right, if there was in the realms of reality, then that's what one would have expected. There had been an administrative slip.
Yes, well,
and so somebody would have sent an email the day after.
Can I get back to you on that, because there was quite a lot of evidence about what happened in this period, and I don't pretend to remember all of it. And the judge summarises some of it, but not all of it.
I suppose on your case that would be irrelevant as well, because that would also be after the event.
Yes, my lord. It's subsequent correspondence.
So we're just really this is just about the email.
Yes.
Yeah.
And that's indeed
on the dispute point. It's just about the email.
Exactly.
The good faith point is one, but on the dispute point, it's just about the email.
It's just about the Clough email. Exactly,
yeah.
my lord. Yeah. 9th was that it's submitted to the correct email address. 10th is that Miss Clough was a member of Siskill's invoice processing support team.
We don't care about any of that. It's just about the email.
But
we cannot accept this invoice.
Yes. But
does the reasonable reader objectively think there is therefore a dispute about that invoice?
Yes.
Answer yes.
Part of that email.
On the dispute point, that's what the judge found. That has to be right, surely.
Well, my lord.
If we're just looking at the email, we cannot accept this invoice for payment. There's a dispute.
Well, my lord, if I may, I'd like to develop my submissions on this.
Well, fine.
With respect, I disagree.
Well, I'm sure you do, but you're telling us about things which aren't relevant. Because we just look at the email. It doesn't matter if Miss Clough is the managing director or a temporary typist.
Well, it does.
She's the person that is, on this analysis, disputing the
No, because part of the email which we're looking at, just the email we're looking at, is the person who sent it. and it's relevant, therefore, to look at the person who sent it. If that was an email that had been sent by Mr. Summerfield, but, for example, the Chief Executive Officer, it would, of course, be read differently to an email that comes from someone who's in the invoice processing support team.
But you have to look at it altogether, and you have to look at the claimant as a single entity. And what one knows here objectively is that there was no purchase order because the claimant hadn't provided one. And the claimant was now saying, we won't pay this invoice because there's no purchase order. So you can't just look at the person who sent the email, you have to look at the whole of the claimant dealing with this aspect. Mr. Summerskill didn't provide the purchase order, and now the relevant person is saying, because there's no purchase order, we're not paying the invoice.
But, my lord, that's why I agree with your lordship about context, and that's why I've been highlighting the points I have, because the leap one makes there is that we somehow knew what Mr. Summerfield had decided. That was never communicated to us. The decision that had been made internally at Sisskill not to issue a purchase order number was never communicated to IBM. We asked for one, they didn't provide one, so we raised an invoice. Those are the facts. Their internal discussions about they're not going to do it and why they came to that conclusion, not communicated to us. So we can't be taken to have assumed anything.
You knew that a purchase order number hadn't been allocated?
Yes, and so we raised our invoice without a purchase order number, but no explanation was ever given to us as to why a purchase order number was not provided. My lord, in a sense, in that your lordship is saying, how did we react? I do submit it is relevant to. It is relevant because it comes from Miss Clough, and Miss Clough is the person on the relevant email, so we do know who it's come from. And she was described, and my lords, it's in the supplemental bundle, tab 20, page 187. This is an extract from Sisskill's closing submissions, paragraph 186. They were arguing about a different point here. This was a waiver argument that they were running at the time. And they said this: the only person who received it, that is the invoice, was an invoicing clerk in Sisskill's accounts payable department who knew nothing about the MSA or Schedule 5 or the requirements for invoices and invoicing. It is idle to suggest that someone in Rachel Clough's role was in a position to determine whether the AG5 invoice was contractually compliant, and absurd to suggest that IBM placed any reliance on the same. That is Sisskill's case.
Yeah, that's what prompted my question as to the natural expectation being an email later that day or the following day saying, oh, there seems to have been an administrative cock-up. Please, can we have a purchase order number?
Yes. Well, my lords, can I give you a definitive answer to that after the short adjournment? Because I'm sure those behind me are beavering away just to look up the further communication. My lord, the point, and in a sense it's a point that's eloquently made for us by Sisskill in that closing, is this: if Miss Clough's email had the meaning and effect of raising a dispute, of disputing an invoice within the context of the MSA, that was entirely accidental. And we do submit, if an invoice was going to be disputed, she would not have been the person from Sisskill to raise that dispute. Now, can we then...
so that was accidental?
Entirely accidental, yes.
But why does that matter?
Why does that matter? We're dealing with, was it disputed?
Because, my lord, read objectively, do IBM expect Rachel Clough to be the person disputing an invoice?
Their expectation is irrelevant. It's a question of whether the invoice, read objectively, raises a dispute.
Well, but my lord, the part of the objectivity is the person who sent the invoice. One can't just ignore who that
So
sent.
this argument is that it can't have been a dispute Because the email came from Miss Clough.
Well, no, that is part of the factual matrix.
No, but
when we
on this
can't
point,
consider whether
it can't have been a dispute because the email came from Miss Clough.
that is part, in a sense, of Siskel's own case in closing this, on the passage I just read to you.
Well, let's imagine you had received a purchase order, and you just forgot to put it on the invoice.
Yes.
And she'd written to you saying there's no purchase order. Seems to me that would have been a dispute.
No, it's an administrative request with respect. There's no dispute of the invoice. It's just saying we need a purchase order number. And that's in a sense, the nub of the point. Miss Clough isn't disputing the invoice. She's simply saying, I need a number, because there's a box I've got to tick.
Well, there's a condition there, isn't there, that for the invoice to be valid and payable, there has to be a purchase order.
But this comes back to the question of what is meant by disputing an invoice. And can I want to show you paragraph 11, which deals with the process of disputing an invoice, because it's quite, if we're going to look at these questions, it's actually quite important for your lordships to understand the contractual.
Para 11 of Schedule 5.
Para 11 of Schedule 5,
Yeah.
exactly. And my lord, if we could go to, so it's in tab 4 of the supplemental bundle.
Yeah.
Can we look at the structure of this? If we start with paragraph 11.7, which is on bottom of page 94. So 11.7, unless the customer disputes an invoice in good faith, in accordance with paragraphs 11 and 12, the customer shall pay correctly prepared invoices properly submitted in relation to payments to be made under this agreement within 7 days. 11.11, if at any time the customer acting in good faith disputes an invoice or an amount shown in an invoice delivered by the supplier, the customer shall pay the undisputed amount, if any, of the invoice within the required period. The customer shall, within 7 business days of receipt of an invoice, notify the supplier in writing if it disputes any element of the invoice with details of the amounts and reasons for disputing the relevant part of the invoice. Provided the customer has given the notice in 11.11, the customer may withhold payment of and meet with the supplier to discuss, and so on. So the notice which IBM has a contractual expectation of receiving, disputing an invoice, is one which has got to be given within a certain period of time, but also has got to give the reasons for disputing the relevant part of the invoice, or the invoice itself. Now, my lords, in Manai, a very well-known passage, but perhaps I can just remind your lordships of it. It's in volume 2 of the authorities bundle. It's behind tab 13, and it's a page 368. But I think my learned friend may have taken you to it yesterday. It's internal numbering, page 771. Starting between letters A and B.
Before we leave 11, clause 11, I'm not sure we've really gone through what the mechanism is there. 11.4 says each invoice shall be quote the unique customer purchase order. Then 11.10, an invoice from the supplier is deemed not to have been correctly prepared if they failed to meet the relevant requirements. In other words, including the purchase order. And then 11.11, if at any time the customer acting in good faith disputes an invoice or an amount shown in an invoice delivered by the supplier. So it seems to me that disputing an invoice includes disputing it on the grounds it doesn't comply with the requirements of 11.4.
Well, my lord, it could do, but
Well, that's what she did.
well, but
She
my
said this invoice doesn't comply with 11.4.
well, but my lord, and it boils down to this: it is Miss Clough's email on its proper interpretation to be read and understood as disputing the invoice or making an administrative request for it to be resubmitted with a purchase
As I've
order
just
number.
shown you, what this specifically provides is that there is a requirement, and the clauses fit together quite clearly, don't they? An invoice is deemed not to have been correctly prepared if they failed, and then 1111 if they dispute an invoice or an amount. So disputing the invoice seems to be plainly can encompass dispute that it's not been properly prepared within 11.4.
Yes.
That's exactly what she did.
My Lord, we'll come back to those provisions, of course, when we're talking about both good faith and relying on its own breach, because the only reason IBM didn't have a purchase order number was because, as the judge found, Syskill wrongly and in breach of contract.
That's a different point.
It is different, but it's part of the dispute. I mean, if we're going to look at the dispute question, part of the only reason it doesn't have a purchase order number is because
Yes.
in breach of contract, Syskill didn't
But
give
that's a
them one.
different point.
Yes, all right.
Which we're going to come back to under
I
a
will.
different heading.
Yes, I
The
will.
question at the moment is,
Yes,
was objectively, under the test in Manai,
Yes.
would a reasonable reasonable reader think that it was disputed within the meaning of these provisions?
yes.
And what I'm suggesting to you is that 1111, a dispute, includes disputing the invoice on the grounds that it doesn't comply with the requirements of 11.4. And that seems to me it cannot be beyond any doubt that that's what that email did.
Yes. Well, my lords, I obviously respectfully disagree, but and I disagree
Why?
for this reason, because if one goes back to the Manai test, your lordship mentioned it, and hopefully you have it in front of you, but it's in determining the meaning of the language of a commercial contract and unilateral contract notice. So this is, for these purposes, a unilateral contractual notice. The law, therefore, generally favours a commercially sensible construction. The reason for this is more likely to give the effect to the intention of the parties. Words are interpreted in the way in which a reasonable commercial person would construe them. And we suggest the reasonable commercial person construing an email received from Miss Clough saying, I haven't got a purchase order number, can you resubmit it with a purchase order number on it? Would
No,
not
saying we can't accept. That's what it says.
Yes,
The relevant words start,
She's invoking,
we cannot accept.
she's invoking clause 11.11 and 11.4. She's doing exactly what she's entitled to do under the contract, which is to say, because you haven't complied with 11.4, under clause 11.11, I don't accept this invoice. She has no other power to reject it than under 11.11.
well, yes, my lord. I mean, she starts actually by saying, "Please, can this invoice be resubmitted with the correct purchase order number on it?"
Yeah.
Not so.
Hence again my request.
Yeah. Well, yes, but she's not. She's clearly not challenging the content of the invoice itself. There's no dispute to the invoice in that sense.
And that's why she's referring to 11.4, which provides for requirements for the validity of the invoice.
Well, I mean, I very much doubt if she, in particular, was referring to 11.4, because I doubt if she even knew about 11.4. But yes, she is simply identifying the absence of a purchase order number, and her internal systems, whatever they are, she wanted a purchase order number. So she's asking for it to be resubmitted with the correct purchase order number. Resubmission of an invoice is not disputing the invoice. Non-acceptance is not disputing the invoice. It's saying, I can't accept this until I've got a number on it. It's not disputing the invoice per se. It's simply saying it needs to be resubmitted. That's the language. My lords, I do submit that although one mustn't be over lawyerly about the requirements of paragraph 1111, it is a contractual provision which has significant consequences because it triggers payment, or the right to withhold payment, which is obviously important. It potentially triggers the process under 1112 and the dispute resolution process. It should enable IBM to know that its invoice has been disputed so that it can then take whatever appropriate steps are required. And that is why 1111 goes on to say it has to be in writing. It has to identify any element of the invoice which was disputed. It has to specify the amount disputed, and it has to give reasons for the dispute. So, my Lord, clearly it's anticipated that a notice to come within 1111 should have a degree of formality, making it clear that the invoice itself is being disputed, not that it's just got to be resubmitted because it's lacking a number. So, my Lord, we do submit. This was no more than an administrative request, and therefore the judge was wrong in coming to the conclusion that she did, which is that this was disputing the invoice.
Can I just go back to the mechanics? It seems to me that the reason for the requirement of a purchase order is so that someone dealing with it administratively, like Mr. Clough, can see that the more senior personnel dealing with it have approved this work. Mm-hmm. And that is why there is the requirement of a purchase order number, and why the absence of that number makes it invalid. It's precisely to arrive at the result we've got, whereas payment is refused because of a lack of purchase number. And it seems to me that is exactly the mechanism that's provided by the clause.
Yes, well, my Lord, can I suggest actually what this clause is getting at? When it talks about disputing an invoice or an amount shown in an invoice, what it actually is about is whether you dispute the sum claimed in the invoice, not whether the invoice itself has some technical deficiency.
No, because that's already been dealt with in 1010. If it's technically deficient, it's deemed not to have been correctly prepared. So it isn't an invoice at all.
Sorry, 1110, my Lord, yes.
The 1110 is deemed not to have been correctly prepared.
Yes, yeah, exactly.
So it's not an invoice.
So, well, but
under the contract, it's not an invoice because it hasn't been correctly prepared.
Yes, but my Lord, if that is right, and it's not, let's just think that through. So if Miss Clough is making an 1110 point where she's saying your invoice hasn't been correctly prepared because it doesn't have a purchase order number, that is different from her disputing, or Sisskill disputing the invoice within the meaning of 1111. Indeed, 1110 actually supports my proposition rather than detracts from it.
Well, no, because it's not a proper invoice. Anyway, I'm conscious of the time.
Yes.
Is there anything else you want to say about whether or not this invoice was disputed?
Well, yes, quite a lot more. Well, not on, sorry, because there were three elements.
Conscious of the time.
Yes.
I appreciate you've had more questions from the court than Mr. Thankey did, but and we'll try and take a vow of silence. But this is only the first element of point 2 out of 5.
Certainly, my Lord. The points get quicker, of course, as we progress. But, my Lord, so, my Lord, you have my point on dispute, and, my Lord, I do make the point, and I'm just going to deal with this quickly, if I may, that we suggest that the judge took into account inadmissible materials. In particular, she took into account, and you'll see this in her judgment at paragraph 326, which in the supplementary bundle in the core bundle behind tab 7 at page 160. Paragraph 326, she says, the judge said, IBM accepted the invoice had been rejected and was in dispute. The invoice, and then she gave 3 reasons for that. The invoice was credited in its internal accounting system and identified as disputed. That's the first. The second, at the CMG meeting on the 3rd of May 2017, so more than a month later, Steve Allen of IBM raised concern at Sisskill's failure to issue a purchase order for the application gate 5 milestone. Ms. Noakes stated that Sisskill's position was that the milestone would become due at the contracted point in the delivery in the programme delivery. At the CMG meeting on the 9th of May, it was recorded that application gate 5 would be added to the table of disputed invoices. That may actually in part answer some of your Lordship's earlier questions. So, my Lord, taking those in turn, the treatment of the invoice within IBM's internal systems, the only evidence about that, or there is some evidence about that, and which the judge didn't deal with, but can I just take you to it, because effectively...
You can't take us to evidence of fact. You wouldn't have got permission to raise issues of fact if this had been an appellant's notice. You can't seek to achieve the same result by a respondent's notice, can you?
No, but, well, my Lord, I'm not...
Trial is the first and last night of the show, as I'm sure you'll have heard trotted out before, and findings of fact, this court has to be very careful about island hopping, which I'm sure you've heard trotted out before.
I'm not seeking to challenge the judge's finding of fact at all. I'm seeking to put it... all the judge said was the invoice was credited in its internal accounting system and identified as disputed. And one needs to understand what that means. That's the only reason I want to show you some evidence. We're not disputing that happened. We're not challenging that finding of fact. But the important point... can I just show you this, and then, my Lord, it will take very little time at all. It's in the supplementary bundle. It's behind tab 18, bottom of page 166. This was the evidence of Miss Hyman, who was a commercial manager at IBM. And at line 25, right at the bottom, it says, in the IBM system, you either have an invoice which is paid or not paid. Anything which is not paid is automatically put into dispute, whether it's in dispute or not. So if you've got a missing purchase order, it would go into dispute. If there was a major error on the invoice, it would go into dispute. So any invoice which is not paid, the only category for it is dispute. It doesn't necessarily mean, I'm sorry, it's just for your information, it doesn't necessarily mean whether an invoice is or is not in dispute. It's just a category we have. It's kind of binary. It's on or off. And there was other evidence to a similar effect, which I won't take your Lordships to. But so I'm not challenging the judge's conclusion, but it needs to be understood in its proper context. Well, the discussion on the 3rd of May was over a month later, and was anyway an inquiry about can we have a purchase order number. And the list of disputed invoices circulated on the 9th of May is, again, irrelevant because it came 6 weeks after the original submission of the invoice. My Lords, in our submission, none of those points actually support the proposition as to whether this was disputed or not. My Lord, that's all I wanted to say on the first of my 3 challenges to the judge's conclusion on dispute. Can I turn to the second point, which is whether it was disputed in good faith? On the assumption that Ms. Clough did dispute the invoice, as your Lordships are aware, both paragraphs 11.7 and 11.11 impose a contractual obligation on Sisskill to act in good faith when it disputes an invoice. The judge held in its paragraph 328 of her judgment that Mr. Summerfield's decision to withhold the purchase order number was wrong, but not so unreasonable as to amount to bad faith. Judgment paragraph 328. And in relying on that as satisfying the requirement of good faith, we make 2 points. The first is this, that the judge's findings related to the withholding of the purchase order number, not the disputing of the invoice by, on this hypothesis, Miss Clough. As noted earlier, there is no evidence that Miss Clough, none was called, no evidence that Miss Clough knew anything about the withholding of the purchase order number or the reasons for doing so. She wasn't called as a witness. The second point is this. The judge treated dishonesty or bad faith as an essential prerequisite for a breach of an obligation, an express obligation of good faith. And that also appears to be the position taken by Sisskill on this appeal, and we suggest that's too reductive. There are, we would submit, 3 first instance decisions which provide useful guidance on this point, because in a sense they each say much the same thing. Perhaps I won't take you to all of them. But can I start with Unwin and Bond, which is in the authorities bundle behind tab 3. Bundle 3 of the authorities bundle behind tab 22.
So before we look at it, what's the proposition, sorry?
The proposition is that an obligation of good faith doesn't require dishonesty. It doesn't even require bad faith.
An obligation of good faith doesn't require bad faith.
Well, my lord, I don't need to go that far, but it's a breach of the obligation of good faith is demonstrated where a party isn't fair and open. So here, if Sisskill were not fair and open in their disputing of the invoice, then in our submission that is a breach of the obligation of good faith, and that goes to the disputing of the invoice.
But you don't say that Miss Clough was not acting in good faith.
No, we don't. But part of the obligation of good faith as well is to give the true reasons for disputing the invoice.
But it was Miss Clough, on this analysis, as you say, it's Miss Clough who's disputing it. If she's not acting in breach of an obligation of good faith, I don't see where the point goes.
Because this is about Sisskill's obligation. Sisskill's obligation, if it disputes an invoice under paragraph 1111 of Schedule 5, is to give the reasons why it disputes that invoice. If the true reason for it disputing the invoice is that Mr. Summerfield has decided to withhold a purchase order number because he thinks that Sisskill has various claims which it can set off against IBM's entitlement to this sum of money, then that is the reason which should have been articulated in some way when it chose to dispute the invoice. It can't, otherwise it's having its both ways. It is breaking the agreement by not issuing a purchase order number. It's not telling its clerical staff. It's then, those clerical staff reject the invoice or dispute it on the basis of simply the absence of a purchase order number, and IBM is simply not told. In the context of an express obligation, express good faith obligation, which carries with it, we would submit, an obligation to be fair and open when disputing an invoice, and that obligation carries with it an obligation to tell us the real reasons why it's being disputed, particularly where the clause itself says such reasons are to be given. My lord, with respect.
My understanding was that when I asked you if we looked at the matter as a whole before, and that Sisskill's decision not to issue a purchase order, you said that one couldn't do that, and that there was no reason to believe that Miss Clough even knew about any of that. And at that point then, certainly in discussions between us, we looked at the specific disputing of the invoice because of no purchase order. One cannot say, can one, that if the invoice is disputed because it doesn't comply with 11.4 on the part of Miss Clough, that was certainly, you cannot say that wasn't done in good faith.
Well, of course, we didn't hear it. We had no evidence from Miss Clough at all. So we are assuming that was that she, because we're told and we accept.
There's no reason to believe it wasn't in good faith.
No. I don't impugn the integrity of Miss Clough in any way. Absolutely not.
No.
But that's not the point with respect. The obligation, it's a contractual obligation on Sisskill, not on Miss Clough. It's a contractual obligation on Sisskill if it's going to dispute an invoice to do it in good faith. And if that obligation carries with it, as we say it does, an obligation to be fair and open with us, then it has to tell us the real reason it's disputing the invoice. It can't rely on a reason given honestly by its own administrative staff, who don't really know what's going on, and which does not tell IBM the true reason for the disputing of the invoice. And my lord, otherwise one is giving no meaning to the good faith obligation. I mean, if they can just allow any administrative clerk to give any reason that's sort of convenient at the time, but not tell us the real reasons, how does that fit in with respect with the good faith requirement of 11.7 and 11.11. An express contractual.
I could see that if the people with knowledge of the contract and all about it were aware that this email had been sent, that it didn't set out the true reason, and they deliberately didn't then correct that there may be some argument then about Siskel, the corporate being, was not acting in good faith. But there's no evidence of that here, is there?
But my lord, isn't the problem with that analysis that this is Siskel then relying on its own internal inefficiencies? The invoice was delivered. The invoice was delivered to the correct contractual address. If Siskel has no internal process which enables that invoice to be drawn to the attention of the correct people, but the invoice is defective not through any fault of IBM's, but because those people, the project people, have decided to behave in a certain way but not tell their administrative staff, then how can they be allowed to rely on all of that when there's a good faith obligation on them to tell us if they're disputing an invoice?
Well, that's very different from good faith.
That's not good faith.
But my lord, if you accept that the good faith obligation, and my submission does, it imposes a requirement on Siskel to be fair and open when disputing the invoice, coupled with an express contractual obligation in the same clause to give the reasons for disputing the invoice, then they can't be let off the hook, in my submission, by saying our internal processes were so defective that this got sent only to an administrative person who didn't bother telling, or we didn't have a system whereby our project team got told, and we can now...
I mean, this is all topsy-turvy, isn't it? Because what went wrong here is that your clients did not have a purchase order. And in those circumstances, they knew under the contract that they could not submit a valid invoice. Now, and they had 3 months left from what you say to sort this out. What they should have done in good faith was write to Siskel and say, look, we need a purchase order, and resolve that issue. What they did instead was send a defective invoice only to the administrative address, not containing a purchase order, perhaps in the hope that it wouldn't be noticed and it would be paid. And what happened was exactly per the contract. Ms. Clough wrote back and said, this hasn't got a purchase order, so we're not paying it. And it seems to me that turning this into some lack of good faith on the part of Siskel is absolutely turning it upside down. Your clients didn't have what they needed. They submitted it only to the administrative office, and it was dealt with administratively as per the contract in good faith. And now trying to say that it wasn't disputed because they didn't pick up on and explain to you they hadn't provided a purchase order seems to me to be making a nonsense of the whole system.
Well, my lord, can I respect this? Just it's topsy-turvy to try and impose the good faith obligation on IBM when the contract...
No, I wasn't seeking to impose a good faith.
Well, I think what
I was saying is it doesn't lie in your mouth to complain about lack of good faith when it was your client's way of operating this that led to it being refused administratively.
No, my lord, with the greatest respect, that's completely wrong. That's the whole point of all of the other issues which Siskel tried. They were playing games here. All of the issues which they took in relation to this invoice...
They were playing games?
Yes, they were. Absolutely they were. They deliberately...
IBM were 31 months late with the contract, and you say Siskel, and IBM spent 122 million on an IT system they didn't get, and you say Siskel are playing games. I mean, I'm bound to say, this aspect of this case, I find surprising.
Well, my lord,
we're simply looking at, the question is there a dispute? We dealt with that. The next question is, was that dispute in good faith? If it's a dispute in the email. That's Miss Clough. She's the administrative person. She's saying no, purchase order number. So the good faith allegation then has to be in relation to Siskel generally. In some way, although they didn't dispute the invoice, other people didn't dispute the invoice because that was Miss Clough, you say, well, they had an obligation to give you the reasons.
It's in the contract. That's what the contract
So
says.
you've had the reason.
We've had a
If it's a
reason.
dispute, if you're wrong about the dispute point, it's because it's been disputed and a reason's been given.
Yes.
Because I quite accept that the contract requires a reason. But if we assume there's a dispute, it's because there's a reason.
Yes, but my lord, the logic, if you're going down that road, is that the reason, and the only reason that is given, is the absence of a purchase order.
Yeah,
That's
which is the only reason Miss Clough could give, because she was an administrative person, not anything else.
Right, but that is not the real reason. That is not the real reason why this invoice was, quotes, disputed, because the real reason was because Siskel had taken a decision, which they hadn't communicated to IBM, that they were not going to pay this sum because of their other complaints about delay and so on. And that's the context in which no purchase order number had been issued. And so, and it comes back to, it doesn't matter which of the good faith cases you look at. I mean, you could use what Mr. Justice Foss said in CPC. The justified expectation of IBM, if an invoice was going to be disputed, was that it would be told the real reasons for that rejection. And we would submit it's commercially unacceptable to reject an invoice for an administrative reason when that's not the real reason why Siskel did not intend to pay it, and then now to rely upon that administrative reason as disputing the invoice in good faith when the real reason's different and not communicated.
But you don't point to anyone within Siskel who both had the knowledge that the invoice had been submitted and the knowledge that there was a different reason for disputing it than that given.
No, but my lord...
You rely on the failings of the system.
Well, we delivered the invoice to the address that we required,
Yes.
to which we were required to deliver invoices.
Yeah. And you say it was their fault for not getting it to the right place.
Well, it's not our fault.
No, but you say that's enough to constitute not
Yes,
being in good
because
faith.
it has been delivered to Siskel, the corporate entity, to the address that Siskel, the corporate entity, says it wants such invoices delivered to.
Yeah.
And if Siskel doesn't have internal processes that enable its project team to be told about invoices that have been delivered that might be contentious, then that really isn't IBM's fault.
No, you have to go further and say it's an absence of good faith. That's your point.
Well, no, the absence of good faith comes from the fact that Siskel has allowed, if you like, its own internal processes to result in an invoice being rejected on a basis which is fundamentally not the real reason. But my lord, and that's the point of the good faith obligation, isn't it? One has to give it some meaning, and the meaning is that you will, in good faith, tell us why it is you're challenging our invoice.
Well, I repeat the point, coming back to the real world, I would have expected an email on the 28th of March saying, why haven't you given us a purchase order number? Is there a problem with this invoice?
Yes.
I come from a construction background where there's cooperation
Yes.
between employer and contractor. That's what I would have expected with both parties acting in good faith. I would have expected cooperation.
Yes. My lord, the judge heard a great deal of evidence about...
Yes, and she concluded it was in good faith.
Yes. I was going to say, the judge heard a lot of evidence about the breakdown of the relationship between Siskel and IBM, which by July 2017, I think she refers to it at one point, both parties regarded the project as coming to an end and were positioning themselves effectively.
Yeah.
So that's the place that both parties were in at the time. My lords, can I then deal with the third point on the dispute?
Yeah.
And that is that if you decide that this was disputed by Miss Clough and that she, in doing so, disputed it in good faith and that's good enough, then in our submission, that is permitting Siskel to rely upon its own breach. Now, the Lordships will recall, the judge found that the deliberate failure by Siskel to issue a purchase order number was a breach of the agreement. And she held that Syskill could not take advantage of its own breach in failing to approve the milestone and to issue a purchase order so as to challenge the validity of the invoice itself. That's paragraphs 279 and 302 of the judgment. And there's no appeal against those findings. Perhaps just worth turning it up. Could we look, please, page 150? It's, Core Bundle, tab 7, page 150.
Page 1.
150, my lord.
Yeah.
Paragraph 279.
Yeah.
So, Syskill was obliged to approve the achievement of the AG5 milestone in January. That obligation was owed to IBM under the terms of the MSA, the implementation, SOW, and the roadmap. In breach of its obligation, Syskill failed to approve the milestone. Syskill is not entitled to benefit from its own default in seeking to avoid payment by asserting the invalidity of the invoice based on the absence of approval. And then, if we move forward to 302 on page 156, 302, Syskill's first complaint is that the invoice did not quote a purchase order number. It's common ground that the AG5 invoice did not contain a purchase order number because Syskill refused to issue the same. As set out above, Syskill's failure to approve achievement of the milestone and issue a purchase order number was in breach of its obligations under the MSA and the implementation statement work, and it's not entitled to rely on its own breach to escape any obligation to pay. So those are very clear findings by the judge, which are not subject to any appeal. And having applied that principle correctly in relation to the validity of the invoice, the judge nevertheless decided that the Clough email disputed the invoice. However, of course, the only reason relied on by Syskill in the Clough email is the absence of a purchase order number. And that, we would suggest, is a very clear example of a party relying upon its own breach. If Syskill's allowed to rely on Miss Clough disputing the invoice on the grounds that it didn't have a purchase order number, when the only reason for that is because in breach of the contract they didn't issue one, that is a right of dispute which is accrued to Syskill only as a result of its breach. And but for that breach, that right of dispute, the only reason for the dispute relied on, would not have arisen. And so we say the Algersane principle arises. Now, in their supplemental schedule...
So I missed that last sentence.
Sorry, we say that the Algersane principle arises.
Yeah, I understand that.
Algersane is in the authorities. I'm rather assuming your lordship. So
Yeah.
you don't, yeah.
So what's the consequence of that, you say?
So, well, if they can't rely on their own breach, then they can't rely on the Clough email as disputing the invoice. And
But
so,
if the Clough email on this analysis disputes the invoice in good faith, then under the contract, they've complied with their obligation.
but my lord, it's the same point.
So they can't rely on their breach to avoid liability, for example, for the invoice. So the invoice has been credited by the judge in her judgment. But what I don't understand what effect you say this has on clause 11.
Well, my lord, I say there's an illogicality in saying that the invoice, that Syskill can't rely on its failure to issue a purchase order number to challenge the validity of the invoice, but it can rely on the absence of a purchase order number to dispute the invoice, which is the only basis on which it did dispute the invoice.
Well, I understand the illogicality, but I repeat the point. If there was a dispute, and if that was in good faith, then under the contract, because as I say, we're a long way removed from the real world and what was happening or not happening on site, I understand that. But I'm just trying to see where this fits in. I mean, I understand the point, and I understand you say, well, it leads to an illogicality, but I don't understand where it goes beyond that.
Well, it goes to this point. If Syskill's not entitled to rely upon the absence of a purchase order number to dispute the invoice, then they have nothing left. They don't have any other
But
dispute.
they plainly were entitled because it didn't have a purchase order number.
But my lord,
This goes back to the question of an illogicality, and I understand that, but I don't see where that takes us.
no, but my lord, one can't. You can't have it one way and then the other way. The court below has already determined that the absence of a purchase order number, notwithstanding the provisions of the contract that we were looking at,
Yeah, no, I understand
11.4, notwithstanding that says you've got to have one, and indeed 11.10, if it doesn't, it's invalid or whatever. The court has said, no, Cisco can't rely on those provisions because to do so is relying on its own breach. By the same token, in my submission, it can't then rely on a dispute which is itself based solely upon the absence of a purchase order number. If the logic of the position, which one has to follow through, is if they can't rely on their breach to say that the invoice was invalid, they can't rely on the breach to say that therefore it can't be relied on, then they similarly can't rely on their own breach to say, well, we challenged this invoice because it didn't have a purchase order number.
Well, I think we have that point.
Yeah. My learned friends give an example of that. They say, well, if it had been, sorry, but yes, I perhaps ought to make this point. There is a distinction here between disputing an invoice on the basis of a mistaken but genuine belief, because that wouldn't offend against this principle. For example, contending that work had not been performed when it had, would not at the point of disputing the invoice amount to a breach, because that would be an exercise of the contractual right to challenge a sum claimed for which the contract then provided a dispute resolution process. And at the time, at the point of time when the invoice in that example is being disputed, it's not, Cisco would not be relying on its own breach. Compare and contrast our position here, where the breach has already occurred. There is a breach, and it is the effect of the breach that is then relied upon to dispute the invoice. And that's why it's very different from the example that was given, I think, given in my learned friend's skeleton, where they say, oh, well, what if they sent an email which said we're challenging this invoice because of all the delays and we have a set-off? Well, that would have been fine. That's what they should have done. But they didn't do that. And insofar as the court determines that the Clough email amounts to dispute, and it's in good faith because she doesn't know why there isn't a purchase order number and she in good faith says there isn't one, then you have to ask the question, why doesn't it have that purchase order number? The answer is because Cisco had intentionally, in breach of the agreement, not issued one, and it therefore can't rely on that breach. My lord, that's issue 2. Can I move on to issue 3, which is equitable set-off?
Yeah.
So, my lords, if the court accepts our arguments on dispute, then it would follow in our submission that IBM was entitled to terminate the contract, and to avoid that outcome, Cisco argues in its supplementary skeleton that the judge should have allowed it to rely on an equitable set-off to withhold payment of the invoice. And on that basis, they say the invoice wasn't due and payable, so IBM was not entitled to serve final notice and terminate. It's a point that was dealt with by the judge in her judgment at paragraphs 331 to 358. In short, we say the parties agreed a pay now, argue later regime under which any payment disputes relating to an invoice needed to be notified within a 7 business day period. If no dispute was notified, Cisco had to pay the invoice without any admission, acceptance or waiver, and there's no carve-out of set-off from that regime. So if
Can I
you
ask you the same question I asked Mr. Thanky? Mr. Thanky said he wasn't aware that set-off was referred to
there are no express provisions
anywhere in the contract.
No, I agree with him.
So you say no carve-out.
No carve-out, which means that if Cisco wanted to dispute liability to pay out under any particular invoice on the basis of entitled to a certain set-off, it needed to say that within the 7-day period, and if it failed to do so, the invoice is payable. And that, we say, is the very clear consequence of paragraph 11 of Schedule 5. If we could go back to that, it's in the supplemental bundle behind tab 4, and if we could pick it up again at the bottom of page 94. So 11.7, can I highlight these words? Unless the customer disputes an invoice, and so on in good faith, the customer shall pay correctly prepared invoices, and so on. 11.9, payment of an invoice shall not constitute any admission, acceptance, or waiver by the customer in relation to the performance or otherwise of the supplier of its obligations under the agreement. 11.11, if at any time the customer, acting in good faith and so on, disputes an invoice or an amount shown, the customer shall pay the undisputed amount, and then he's got to give his reasons. And then 11.12, provided the customer has given the notice in paragraph 11.11, the customer may withhold payment of and meet with the supplier to discuss the disputed amount. So that is we would submit, a very clear and unambiguous regime which requires disputes, and in a commercial context it's important, we would submit, for disputes to be identified, particularly if they relate to sums that are going to be paid or not, for them to be identified, and if they are, then you go into dispute resolution, and if they're not, then the invoice gets paid. Now, my learned friend's supplementary skeleton focus is paragraph 31. Focus on the words disputes an invoice or an amount shown in an invoice, and they argue that a party that relies on set-off does not dispute the invoice or any amount shown in the invoice, with the result that the right to withhold payment on the basis of set-off is not caught by 11.11. We submit that that misses the point. This is a commercial contract. It has to be construed commercially, and on a proper construction of 11.7 and 11.11, disputing an invoice or an amount shown in an invoice means disputing liability to pay it. That's surely what the parties must have intended it to mean. And that, we say, is obvious from paragraph 11 as a whole, because, and in particular, the requirement that if it's not disputed in 11.7, and indeed, but primarily in 11.7, unless the customer disputes, the customer shall pay. So the regime clearly envisaged that if an invoice was going to be challenged, it needed to be done within that period of time. And there is, accordingly, we would submit, a binary division between invoices which are not disputed, which are therefore due and payable, and those which are disputed, which means that payment can be withheld, paragraph 11.12. Siskill's contention would introduce a third category, namely undisputed but not liable for payment. That, we suggest, would be commercially unworkable and clearly not what the parties intended. And the law of equitable set-off, as explained in Ferns and Anglo-Dutch, doesn't in any way detract from our argument on this point, because if one looks just at one small part of the judgment, Mr. Leggett, as he then was, it's in the authorities bundle, it's bundle 1, tab 9, we pick it up at page 192. And it's a paragraph that my learned friend, I think, read to you yesterday, paragraph 21, where Mr. Leggett said this, if you pick it up at the second sentence in paragraph 21, in particular, it's now generally accepted that an equitable set-off can be relied on outside the context of legal proceedings, and that, and these are the words I highlight, where such a set-off is properly asserted, it can prevent a person from exercising contractual or other legal rights which that person would otherwise have. Now, in the context of this commercial contract and to make it a workable commercial contract, in our submission, plainly, if Siskel is going to assert a right of set-off, which means that it then doesn't have to pay, that is something which the parties clearly envisaged would be done through the paragraph 11 regime in Schedule 5. Because otherwise it leaves IBM in this hopeless position of not actually, of believing an invoice is undisputed, believing that it's entitled to payment because the clause says shall pay, and then, as indeed happened in this case, before any letter invoking a set-off was reached, going down the road of exercising termination rights. So in our submission, that would be a very surprising outcome. Now, Siskel also rely on the language of clause 26.7 of the MSA, and for that we need to go back in the supplemental bundle to tab 1, page 49. And 26.7 says that the supplier shall have the right to serve on the customer a written notice if the customer has failed to pay undisputed invoiced amounts which in aggregate exceed £1 million sterling, and which have been due and payable for a period in excess of 45 days. Any such final itemised undisputed amounts and so on. If the customer fails to pay such undisputed invoiced amounts, the supplier may terminate this agreement immediately. And in our submission, it's suggested that there's a difference between undisputed invoice amounts on the one hand and due and payable on the other. But we say that's built on an unnatural reading of 26.7. On its proper construction, undisputed invoiced amounts must refer to invoiced amounts which have not been disputed pursuant to paragraph 11.11 and 11.12 of Schedule 5, because one has to give these words the same meaning in our submission, particularly because they're all surrounding payment. And those amounts became due and payable 7 business days after receipt of the undisputed invoice pursuant to paragraph 11.7, because that's what 11 says. If they haven't disputed it, then they shall pay and remain due and payable until paid. And we submit that otherwise, any other interpretation would make this a commercially unworkable agreement and leave IBM in the position where it simply doesn't, it thinks, because it's gone through its Section 11 procedure, rendering the invoice and all the rest of it, paragraph 11 procedure, it believes and understands its sum is due, and then suddenly out of the woodwork, and much later than it should have been told, it gets told, oh no, we've got some sort of equitable set-off. The judge, the other point that was considered by Maloney Friends, was advanced by Maloney Friends, is the clear words are needed to restrict valuable rights argument. And that's a principle that was expressly considered by the judge. It's in her judgment of paragraphs 346 to 345. We don't dispute the principle, but it shouldn't be used to upend what we say is a common sense payment regime. And indeed, Maloney Friends' skeleton requires a bit of careful reading on this point. If I could take you to it in the core bundle behind tab 5 at page 75. So at paragraph 32, what is said is this: clear words are required to exclude rights of set-off. And then this: and by extension to subject set-off to a short notice regime.
Sorry, which paragraph are you in?
Sorry, paragraph 32.
32, yeah.
It's the first sentence. So clear words are required to exclude rights of, and by extension to subject set-off to a short notice regime. See Lord Legate in Triple Point. Lord Legate in Triple Point was, of course, considering exclusion clauses, not short notice regimes. And the extension that is suggested there, without any proper explanation or analysis, is not one that, in my submission, stands up to analysis. And particularly in this case, whereas the judge noted in paragraph 350, the payment regime in the contract does not exclude rights of set-off. So, for example, after AG5, there was nothing to stop Siskel when IBM delivered its next invoice from raising a set-off, just providing it did so in accordance with the paragraph 11 regime. It's all about certainty of contractual performance. In our submission, the contract is perfectly clear on this.
Mr. Fuzzy, can I just ask you, if there is a set-off raised, you say that stop an invoice being payable. But it seems to me that if there is an acceptance that there is a set-off or a credit, and indeed it's referred to in paragraph 11.8 of the contract, it's recognised that you might issue credit notes. Now, it seems to me if you've issued a credit note, plainly that can be set off against an invoice, can it?
Yes.
And yet, the invoice. So in that situation, although an invoice is not disputed, it is not payable.
Well, 11.8 says refunds, credits or rebates shall be payable or credited to the customer. So, I mean, this is just an accounting regime, isn't it? So they'll either be the sum will either be repaid or it'll be credited to the customer. In other words, effectively, when AG5 comes in, if they've agreed that they've got a rebate of $1 million, then that would be deducted from any payment that was made. But they wouldn't be disputing, as I understand it in that context, the invoice. They would just be saying, well, we've got our credit note here. But that is an entirely different, I would submit, entirely different.
Why a credit note or a refund credit or a credit note are only formal recognitions of what may be said to be an equitable settlement?
Well, it's an acceptance of a liability, isn't it, or a right to a refund. But my lord,
That's what a set off.
Well, my lord, it could be, but it's not. My lord, I would submit there's a real difference between a sum that is, if you like, in a credit note such as this, and a sum that is a challenge to an obligation to pay under an invoice.
The difference is that you have accepted the set off in the case of 11.8.
Well, in those circumstances, but that's just simply an accounting exercise.
So is the set off.
Well, but my lord, the problem is, my lord, you are creating this hybrid position. Instead of the clearness which commercial contracts, and courts tell us this time and time again, rightly, commercial parties expect to know where they stand, particularly when it comes to payment. There needs to be clarity about, has an invoice been raised? Yes. Is it due? Yes or no? Is it challenged? Yes or no? If it's not challenged, then it's got to be paid. And that's essentially what this regime says. And I do submit that to allow equitable set-off to intervene in what is a very clear contractual structure would be to create an anomaly and actually introduce ambiguity into a commercial arrangement that was actually perfectly clear, and one can see what the intention of the parties was.
Well, it often does, doesn't it?
Yes, but in a sense, I come back to the intention of the parties. The intention of the parties, I would submit, I mean, the agreement is deficient in the sense that it doesn't expressly deal with set-off, but the intention of the parties is perfectly clear, I would submit, from the paragraph 11 regime, that it's pay now, argue later, unless you've raised the point.
Yes, and on that, I mean, I may have to look at it, but it may not matter. Pay now, argue later obviously comes from the sort of the adjudication context. And in that context, certainly, you can't avoid payment after the event by reference to an equitable settlement. In general terms, you can't.
Right.
There are some, it's not quite as simple as that, but in general terms, you have to, going back to your point about nature of any accounting exercise is, you under that regime, you have to identify, even if it is a set-off, even if you're accepting your invoice is due, but actually I'm not paying it because you owe me twice that amount, you have to set that out within the time frame. Of course, the difference here is that there isn't provision for withholding notice, as they're called, but you say that's why you have to give a commercially sensible interpretation of the word dispute.
Yes. Yes.
For this purpose.
For the purpose of this.
For this purpose.
Yeah.
Yeah. Okay. Well, I understand that point. Okay. Does that deal with 3?
That's 3, my lord.
Right. Well,
So-
I said to myself this morning that if you'd finished 3 by lunchtime, we would allow Mr. Thankey his 3:45. So that was my timing, but obviously I'm not doing the submissions. I'm just doing the interrupting. But that was the target I set myself. So we've allowed you 5 minutes more, but in the circumstances, I think that's
Yes. But I'm grateful.
not ungenerous.
No. Well, my lord, I won't be too long on issue 4, and issue 5 is really very short.
Issue 5 being the cap.
Caps. Yeah.
And remind me, issue 4 being...
Issue 4 is what I'm calling causation.
Oh, yeah. Fine.
Quite
Yeah, okay.
satisfied.
Well, I'm speaking for myself. I'd be confident that we would finish before 3:45 for Mr. Thankey, but that's the time frame we're in.
And so am I.
Okay, 2 o'clock. Thank you.